You'll tell us when you're ready, Mr. Majavu. No, there. I know it's you, but just tell us. Take your time.
Good morning, Judge colleagues. Ms. Jiba is ready. She will be led by Advocate Masuku. She has also instructed me that she prefers to take the oath standing.
Please state your full names for the purpose of the record.
Nomgcobo Jiba.
Will you take an oath or affirmation?
Oath, madam.
Okay. Do you swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, madam.
If so, just raise up your right hand and say, "So help me God."
So help me God.
Thank you, Ms. Manda. Mr. Masuku.
Thank you, thank you, Chairperson and the panel.
Before you do that, good morning, everybody.
Good morning.
We have had some issues with regard to security, parking. The security are finding it particularly difficult to handle the constant demands by, they say, the media for parking space. Arrangements had been made from day one that certain parking spaces would be reserved for certain people. These are not our premises. We're using the premises of the Law Reform Commission. They have their own staff who park in reserved parking bays. And we would ask, particularly the media, it seems like there's a problem between the security and the media. The security complain that the media doesn't respect their directives. Can you kindly, when you are asked not to park inside the space and rather park outside, because it is done for particular reasons, will you kindly cooperate with the security? Because they report to certain authority, and if they do not ensure that there is no undue contestation for parking bays, they are said not to be doing their job. Can we kindly give them their our cooperation and assist them to manage particularly the parking space? We expect to get your cooperation, and we anticipate your cooperation. So I thank you. Sorry about that, Mr. Masuku. You may continue.
Thank you, Chairperson. Chairperson and the panelists. Before I commence cross-examination, sorry, before I'm used to cross-examining, so before I lead my witness, we've prepared a document which we intend to hand up, preferably at the end of her evidence. I'm not going to follow the sequence of the document that we've prepared because I think it's easier to just flow without being constrained by the document, but it is for the benefit of the panel to see exactly how Advocate Jiba intends to deal with the issues that she's supposed to deal with. But the second thing is she would like to start off by making an opening statement. If the panel is okay with that, I would invite Advocate Jiba to make her opening statement before I lead her evidence. That opening statement is part of the evidence, but we've structured in such a way that it would start off as an opening statement.
You're welcome, ma'am, to do that. Okay? You may proceed.
Thank you very much, Justice Mokgoro. When I became a prosecutor in 1988, like most South African and African girls, I never dreamt that one day I would serve my country and society as a Deputy National Director of Public Prosecutions. My vision did not stretch as far as that because the circumstances of our growth did not allow us to see ourselves as leaders of society. However, inspired by the ideal of justice and the rule of law, my vision grew with my experience as a prosecutor from a township of KwaZakele, a very dusty area in Port Elizabeth. My eyes began to open to unlimited prospects of serving my country beyond a township girl, but to a prosecutor. I am glad to have had parents who inspired me to see myself beyond the confines of my community. I love the work that prosecutors do. I am very passionate about being a prosecutor. Society would collapse into self-help chaos without this group of dedicated prosecutors. The rule of law depends on the work that we do as prosecutors. I found my calling as a prosecutor and was deeply inspired by the sense of justice that powered the work of prosecution. I realized that whether in war or peacetime, we need prosecutors who are courageous champions of justice and defenders of the rule of law. Whether in a constitutional democracy or in a dictatorship, society needs prosecutors who reflect the values and principles of society on life, liberty, and property. I was promoted to the position of a senior state advocate, then a deputy national director, a deputy director of public prosecutions, and thereafter to the position of a deputy national director of public prosecutions. As a South African in particular, an African woman, these promotions were very inspiring milestones for me personally, but for society in general, because they reflected a commitment to ensuring that senior prosecutors in our constitutional democracy reflected the racial, gender, and professional balance necessary for the legitimacy of such a strategic institution. Justice Mokgoro, the promotion, however, were never celebrated by all within the National Prosecuting Authority. As I recently found out, when evidence was being led at this inquiry, I was shocked to learn that people who I considered my colleagues and committed patriots felt that I was not qualified to lead the NPA. The testimony of Advocate Brettenbach and Mr. Hofmeyer in particular revealed a deep resentment that a young black African woman had been promoted to this leadership position. Many difficult questions I had nursed about them were answered when, in frank terms, they confessed to their belief in my ineligibility for promotion to the position of a Deputy National Director of Public Prosecutions. First, I learned from these two witnesses that my reliance on them to steer the NPA to the heights of glory would actually be misplaced. And secondly, I wondered why they believed that I was not eligible to serve in the position of a Deputy National Director with the qualifications and experience that I had. I am left to speculate about their beliefs in my experience and qualifications. I faced unprecedented attacks not recorded in South African history. So unfair, harsh, and vicious were these attacks that it prompted the Minister of Justice and Constitutional Development to issue a public statement in my defense. I was not particularly concerned about the attacks from the political parties, the Democratic Alliance, because I hope that the attacks would thaw with time as we engage with each other in parliamentary forums where the NPA would be required to account for its work. I hoped to win my critics by demonstrating a principled level of commitment and integrity in the performance of my work. The litigation against the NPA intensified, focusing particularly on a number of issues. The hostility of Mr. Hofmeyr, as for it, I can truly state that it did not come as a surprise. I did not believe that Mr. Hofmeyr was ready to report to an patriarchal and old habits really die hard. I heard Mr. Mrwebi here often referring to guys, gentlemen, because that is our society, and forgetting that we are also in these particular positions. In essence, Mr. Hofmeyr scandalized the NPA by his unfortunate statements on the NPA. In a non-precedented attempt to take away from me any prospects of serving as the leader of the NPA, he manufactured dangerous and unjustified,
Judge, may I ask for an indulgence? Technology just failed us for a second.
It's fine.
You chose an old man, you could have chosen a young woman to help you.
And the woman comes to the rescue.
And the young one.
I did ask her to help.
Credit goes to Mr. Masuku.
And she happens to be my daughter and my associate.
Thank you again, Chairpersons.
You're welcome. Welcome.
I was still saying, in an unprecedented attempt to take away from me any prospects of serving as the leader of the NPA, he manufactured dangerous and unjustified political theories in assessing what had gone wrong in the NPA. He failed to understand that his views of the NPA were hateful to the standing of the NPA because they were made without any shred of evidence. My family and friends and colleagues in the NPA remained hurt by these reckless statements. His utterances on the NPA, they should disqualify him from being its servant. My little children have asked many times, why, Mommy, are you always in the newspapers and in the media generally? My children are very young. They go to school. They've got friends. And at times they have to answer to their friends. I have had to assure them that there is peace after the storm and asked for their support. As all children, they readily offer such support unreservedly. The years of public relegation have been extremely and very painful to me. And while I have developed a thick resistance to it, I have felt the promptings of human frailty. The inquiry is a platform I hope to heal from, whatever the outcome. I'm finally judged by the persons sitting right here whose integrity and sense of fairness I trust completely. I welcome this inquiry as an opportunity to account for my years in the NPA leadership. What is comfortable is that the inquiry is held in the public, so my critics and society in general can see the truth. Whatever the outcome, I cherish the moment to speak for myself and in my own words. In the following days, I will listen to myself and speak what I have wanted to say for some time now. The NPA is bigger than any one of us. It is a national treasure that must be treated with reverence by all of us and honored for its indispensable constitutional role in preserving the rule of our law. Our constitutional democratic system depends on what the NPA does. A weak NPA will undermine the goals of our constitutional system. A strong NPA will promote our constitutional goals, and as a senior leader of that particular institution, I sleep soundly because I know how hard my prosecutors from the corners of the Eastern Cape up to Amanzim Dodi in KZN, from the rural areas, some of him are at Mkanduli, where there's even no electricity. I know that those people are hard at work. These are dedicated patriots, Chairperson, who value the NPA and will never permit it to be used to achieve corruption, criminality, and thuggery. For many years of reading and hearing criticisms against me, I have maintained silence on the advice of my legal team, particularly Mr. Majavu, sitting right next to me, preferring to speak only through my work. This inquiry liberates me to speak and air my views on the NPA that I have diligently and faithfully served for 27 years. 27 years, I'm sure you'll all agree, is no child's play. I might look young, but I'm actually very matured. Let me close by expressing my gratitude firstly to my husband, to my family, for their unwavering support, to members of my church, and everybody who has supported me during this time. I stand at this inquiry with a clean conscience and ready to speak to all on what I have done with the responsibility that I have been given to serve my country as a Deputy National Director of Public Prosecutions in the National Prosecuting Authority. Thank you very much, panel, for offering me this opportunity. And thank you very much, Advocate Bauer, and your team, indeed, for offering this opportunity to me.
Thank you.
Thank you. Thank you so much for that statement. And I think we'll take it from there.
Yes, thank you very much. Thank you very much, Advocate Jiba, for your very considered opening address. You've been in the NPA for a number of years. I think you mentioned 27 years, but am I correct to say you probably meant 17 years? 27 years. 27 years. So 27 years of service in the prosecution services.
Yes, Counsel.
Right. Now, you're now before this inquiry. You are aware of that the inquiry has been constituted to determine whether you're fit and proper to continue serving as a Deputy National Director of Public Prosecution, right?
Yes.
You've read the terms of reference that this panel must work in accordance with in order to make that determination, right?
Yes.
But prior to this inquiry being constituted, you were invited at different times, and I'd like to share that experience at different times by the former President of the Republic, Mr. Jacob Zuma, and the current President to give them reasons why you should not be suspended from the position of the Deputy National Director of Public Prosecution.
Yes, Councillor.
Would you want to reflect a little bit on the circumstances, the first circumstances by former President Jacob Zuma, when you were asked to make submissions on why you should not be suspended?
Yes, Councillor. The GCB had launched an application to have my names and that of my two colleagues, Advocate Mrwebi and Advocate Mzinyati, struck off the role of advocates. And the GCB had then succeeded partially in that, had succeeded in fact in getting our names struck off the roll with the exclusion of Advocate Mzinyati. We had then lodged an application for appeal before the Supreme Court. And at the same time, we had voluntarily, that is myself and Advocate Mrwebi, offered to go on special leave. So when the President wrote this letter to me, and I suppose to Advocate Mrwebi as well, we were already on special leave. So we're not in the office performing any functions at the time.
Yes.
So we made those submissions, and in particular, I made those submissions to say that, you know, I'm already sitting at home on special leave. And I also made a point that the matters that you would like to ventilate in the inquiry are currently matters that would be ventilated in the Supreme Court of Appeal. And as such, indeed, they were ventilated in the Supreme Court of Appeal. And I think the judgment of the Supreme Court of Appeal is part of the documents which is in the Dropbox.
Yes.
Where the majority of the judges, they had found that I had committed no misconduct. Yes.
And that you are a fit and proper person to remain on the role of advocate.
Yes, Councillor.
Right. And then after the Supreme Court of Appeal judgment, of course, you got suspended again. I mean, you were invited again by the current president, Cyril Ramaphosa, to address him on why you should not be suspended.
Yes.
And then you make those submissions.
Yes, I did.
They are in the Dropbox, as we all know.
Yes, Councillor.
Now, as you know, this inquiry was constituted to investigate and make a determination on your fitness based on, amongst others, remarks and adverse criticisms that were leveled against you in different judgments. We'll go through those judgments. And then an issue that then also came up while this inquiry was sitting, relating to evidence that had been led in the Commission of Inquiry on State Capture before Deputy Chief Justice Zondo of Mr. Grizi, right?
Yes.
And so we will then deal with the criticisms of the courts and then deal with the issue of the issue relating to the allegations made by Grizi. Is that all right?
Yes, Councillor.
Right. Now, let us deal with each of the, I'll start off with the Boysen matter, because in the Boysen matter, as you heard from the evidence of Willie Hofmeyer, essentially you are engaged in unlawful prosecution of Mr. Boysen. Can you take the panel into your confidence on how the issue of Boysen was dealt with? And in doing so, respond to what Willie Hofmeyer's allegation that this was a prosecution that was unlawful, how that in fact is probably, whether that is in fact the case.
I want to state from the onset that there is nothing unlawful about a decision that I made in issuing the racketeering authorization to prosecute General Poison and others. You see, Chairperson, when you deal with a prosecution in terms of Section 21E and Section 21F of the Prevention of Organized Crime Act, your focus is not necessarily on the on the general, for lack of a better word, on the general standards of charging, of saying, accused number 1, you are charged with murder, accused number 2, you are charged with murder, or assault, or rape. The focus and the intentions of POCA, in particular these two provisions that I have mentioned, the intention of the legislature there was to allow us to be able to touch those who will never be touched by the law and by the might of the law, precisely because they never get to the scene of crime, but they have others that are at the scenes of crime. In a nutshell, that is the objective of Section 21E and Section 21F of POCA. And those authorizations can only be made by a National Director of Public Prosecutions. Now, what happens there, naturally, both provisions, they tell you what are the requirements for you to be able to charge a person in terms of those provisions. In terms of Section 21F, I must show evidence to the fact that there is an enterprise, that there is a manager, and that the operations of this enterprise are conducted through a pattern of racketeering activities. And in Section 21E, I must show that there is an enterprise, and equally that its affairs or operations are conducted through a pattern of racketeering activities. But the difference between the two is that in 21F, it is sufficient the state has evidence to prove the management and the knowledge of what this enterprise is actually doing. But in Section 21E, the person that I am charging must also participate in such a conduct. So that is the basic difference between the two provisions. So in this case, there was a meeting in my office, I think with the members of IPED, IPED has got powers to investigate the conduct of police officials. So IPED was assigned with this particular case to investigate the conduct of the police officials in Kaitomano in KZN. They had concerns that the case was not moving. There was basically nothing which was done, yet I think there were serious newspaper articles and commentaries at that time that KZN police officials killing 117 people in 1 year. So then we had this meeting, and their request was simple to me, that I must assist them in ensuring that the case is attended to. And they did express concerns about the fact that the members in the NPA, in particular in KZN, were known, or that they knew each other, because I could understand that they were colleagues. Those were police officials in Katumano, so they were colleagues and all of that. I did not necessarily cast aspersions to my prosecutors in KZN, but for the sake of making sure that what is required is complied with, I set up a team that consisted of a number of prosecutors. There were senior state advocates, and I think there were also junior state advocates, and then there were deputy directors of public prosecutions. Advocate Mayema was from the Northwest, and Advocate Raymond Matenjwa was from South Gauteng, and there was also Advocate Mlochwa, I can't remember where from. And then there was a group of senior advocates, because one of the ideas is that I want to put seniors who are also going to transfer skills to the junior officials, because we don't want a situation that it's only senior officials who are going to run with the case.
Sorry, did you say Mlochwa, the gentleman from KwaZulu-Natal? Or is this another Mlochwa, or did I mishear you? Another one?
There are two Mlochwas, madam. It is not Advocate Mlochwa from the acting DPP who was here testifying. It is Advocate Mlochwa. I think he was from the Free State. Yes. She was also a deputy. So then I assembled this team. Then in my office at the time, in fact, when I was appointed to act as a national director of public prosecutions, I found a team of advocates that were called special projects. They were assigned to do special projects and also organized crime. Advocate Mozing became part of this team. He is a deputy director originally who was in leading organized crime from North Gauteng. So then I requested him to work closely with the prosecutors in this case, so as to ensure that by the time that if there's a need, by the time that an application for authorization is submitted before me, he would have been there as a liaison between myself and this team of prosecutors to ensure that all the elements, we have all the evidence that then covers all these particular elements. And the investigation proceeded. And I was having briefings constantly on the case. I was really kept informed about the development of the case, but I'm not a person who micromanages people. I allow people to do their work and come to me when they are of the view that they are now at a stage whereby they must come and brief me, and that is actually what happened. Now, I don't know how far should go a chairperson in showing the evidence that was presented before me to enable me to agree with the recommendations that were made. And I'm saying this, I do not know how far I should go, because the evidence that was presented before me is it has very gruesome photos of people that were killed. I have not had the opportunity of talking to the victims or to the relatives of these people to show that I will be showing this evidence before this inquiry, essentially. So I'm sensitive also to their own feelings at home, and you must imagine that this case has been postponed so many times. And they are sitting and hoping that at some point in time, the case will be prosecuted and this evidence will be produced before a court of law in their presence. But I'm sitting here at the inquiry. I do want the inquiry to see for itself the evidence that was presented before me, which really made me to issue these authorizations. But I really would want to seek guidance. This is something I have said to my legal team, that I would want to seek guidance because I do not want to unnecessarily upset the feelings of the people. And as I know and I assume that these proceedings are live and everybody else will be able to see them.
Honorable Chair, essentially, as I understand, the witness should seek your guidance on whether she should go ahead and provide the evidence that she considered when she was issuing an authorization to prosecute Mr. Poison, to answer the allegation that the prosecution of Mr. Poison is unlawful, or that the prosecution of Mr. Poison has no basis. The fears that she has are legitimate, but we would want a ruling from the panel on whether or not she can show that and describe exactly what she was asked to consider when she was considering the authorization in terms of poker, which would include photographs that will be shown all over the televisions of people who were killed by the police.
I understand what it is that Ms. Jiba wants to show, and I appreciate your reasons for wanting to show those pictures. I appreciate. And I have not consulted with my assistants yet, but I think what is critical is the position of family members. You say yourself that you haven't asked for their permission, and it would be very difficult to sit here and make a decision that says you may show the pictures without having consulted with family members, okay? And I think it is a decision which should not be taken lightly. And for that reason, I think I would like to confer with my co-panelists and come back to make a ruling.
Thank you, Chair. In the meantime, we can proceed
I think
with other aspects of the case.
I think in the meantime we can proceed, and we will determine that matter at a later stage.
Yes, thank you.
Yes, thank you.
Ms. Jiba, you filed an affidavit in the case that was decided by Justice Govan, on which the issues of Mr. Poison were dealt with. It was an application brought by Mr. Poison to review that authorization that you had granted. Am I correct?
Yes, Counsel.
Firstly, would you just respond to Mr. Hofmeyer's assertion that there is a committee that deals with authorizations?
To the best of my knowledge, I have acted as a National Director of Public Prosecutions. Advocate Simelane was a national director of public prosecutions. I was his deputy. I am currently a deputy national director of public prosecutions. I have never seen such a committee, but what is in place is a team of advocates, as I have indicated, that are led by Advocate Mozing, that have a responsibility, and they work with a number of provinces. So when we receive the application typical for authorization coming from a DPP office, it is those advocates under his guidance, Mozing's guidance, that then communicate with the prosecutors, particularly in organized crime, because these kind of matters, they emanate from organized crime unit. So they communicate, they travel, they sit down, they discuss, they look into whether there is sufficient evidence that covers all the elements of a 21F or a 21E authorization, and that is what essentially happens. Even in the period when Mr. Nxasana came as an NDPP, that remained the position. The only difference with Mr. Nxasana is that he removed that, he just changed the reporting structure and removed that particular unit from his office and transferred it to the NPS, where I am currently right now. And even at the stage of Advocate Abrahams, that is the position that actually remained. So we don't have a committee that where prosecutors come with a bundle of dockets to make a presentation. We have a team that assists in the evaluation of those applications before they are submitted to the National Director of Prosecutions. The system, before I was put on suspension, currently operated in that fashion. So the final document, before it gets to the National Director of Prosecutions, it would come to me. Depending on whether I am satisfied with what is contained in this actual memorandum, I would also invite the prosecutors themselves from organized crime to make that presentation to me so that I am satisfied before I sign off, recommending that the NDPP, at the time it was the NDPP acting Put Silas, Dr. Ramayita, I normally call him Put Silas. So I would then submit those authorizations to him to authorize, yes. The reports on these matters, I have my report, I have the report somewhere. The reports are compiled by Advocate Mozing. I think I had two, was compiled for 2012-13, and the other one was compiled for 2013-14. It would then be a report that is incorporated in our annual performance report that we then have to present before Parliament in the Portfolio Committee.
Thank you. And then let's go to Justice Govan's judgment on the poison matter. You were criticized in that judgment. You remember the criticisms, right?
Yes, Counsel.
And what is your response to them? Oh, but before you answer that, you did file an affidavit in that application, right? And you stand by what you stand by what you filed in that application?
I sometimes nod and I forget to say yes, Counsel. Yes, Counsel.
Partner. Yes, Chairperson.
Yes, Chairperson.
I was wondering if there's a private conversation between you two. And we are just spectators.
Yes, Chairperson. I must apologize. Yes, Chairperson. Yes.
So now, what is your response to the criticism that Justice Govan made against you, and in particular in relation to the statements you had made in that affidavit?
The unfortunate part about that case itself is the fact that we briefed counsel there, Advocate Hodes, SC, whose view was that there is no need to file a Rule 53 record. So the criticisms of Judge Govan were premised on the fact that there's insufficiency of evidence which has been placed before him precisely because we have not provided him with a Rule 53 record. But the affidavit itself had given a summary of the nature of the evidence which led to the institution or authorization of the prosecution in terms of both sections. Of importance, Judge Govan did not say that an authorization could never be issued. The only issue that he had was the fact that there was insufficiency of evidence which was placed before him. That is the first part.
Yes. For the sake of the record, you might want to expand on what the Rule 53 record actually entails. Just for full understanding of what was required, you might want to just explain what a Rule 53 record means or entails. Okay? Just for the record.
Essentially,
just briefly.
Yeah, okay. Essentially, Chairperson, thank you for that. The Rule 53 record would have required me to place evidence that was particularly presented before me, that influenced me, that formed the basis of my decision to authorize the racketeering. Essentially, I would have had to show that this evidence, on application of the principles of Section 21F and Section 21E, this particular evidence supports the authorization. So that is the kind of evidence that I was supposed to have then placed before him.
Thank you, that's sufficient.
Thank you, Chairperson.
And then, of course, following the judgment of Justice Govan, you were then charged by the NPA, and you had the evidence of Advocate Ferreira, who was your prosecutor. I almost said persecutor, but prosecutor in the case. You were charged for fraud and perjury arising from that judgment. What is your response to that process?
Chairperson, this is one of the issues that in my closing I would like this inquiry to reflect upon in strengthening our prosecutorial independence. I have never felt so betrayed by my own institution in my entire life. When I was paraded before a court as a criminal, merely for exercising a discretion. I could not understand, and I looked at Jan Ferreira. Jan Ferreira is my colleague. I've worked with him in the Special Commercial Crimes Unit. I could not understand what is it that he is talking about, because there is sufficient evidence in the docket, at least, that I saw from the information that I read. It's a pity that counsel is asking me this question before the chairperson has ruled on whether I can produce this evidence or not. People were killed in circumstances where they posed no danger at all. And they were killed, some of them in front of their own wives. And the only defense that was afforded by the, I don't know if I'm allowed to refer to them as accused or what, but the only defense that was afforded by the perpetrator was that they were acting in self-defense. None of them ever got injured, shot at in this self-defense. And in any event, when Jan Ferreira said that they were acting in self-defense, I don't believe that as a prosecutor, I can simply say, no, I'm not going to prosecute because we're acting in self-defense. I believe it is a court of law which must actually adjudicate on whether there is indeed self-defense or whether this self-defense has not been exceeded. I cannot, in the face and mount of gruesome killings that were presented to me, 28 people were killed in that case. And none of the police officials sustained any injuries. They were killed in circumstances where they were subdued. They could not have rendered any attack on the police officials because these police officials would come as a group, kick the doors. So all I'm trying to say is that there wasn't evidence that the police officials were necessarily attacked by these. This is not a situation whereby you find a group of gangs in one house. It's an individual sleeping with his wife and children. So that is why I was lost as to where does Jan Ferreira take, which docket did he particularly read? That was not presented to me. And by the way, I want to state it that Advocate Mayema is one of our most experienced deputies in this field. I do recall at some point that he surprised us all. We normally defined an enterprise as a legal entity. We focused on the legal entity and a group of persons as the definition allows us to do so. But we never read the word any individual, because in the definition of an enterprise, it also says any individual. And when he argued this case before the SCA, I will ask him to just tell me what that case was. We were all saying, whew, this one is crazy. And trust me, the judges agreed with him. So he's an expert on this field, the real expert now on this field. That is why I put him in this particular team. So the long and short answer, Chairperson, is that I was amazed by what I heard from Jan Ferreira. I was extremely disappointed and hurt that the institution found it so easy to turn tables, charge me for doing my job, and leave those that are supposed to go and answer for the wrong acts that they have committed.
Now, as far as you know, is there any case pending against you arising from what Mr. Ferreira testified to?
You know, Chairperson, this is a very funny case. It gets withdrawn, and then it gets, the history of it is that it was withdrawn, and then it went to court. And as far as I know now, is that there is a decision which was made by the director of prosecutions in the Northwest to decline to prosecute. Although I have not received a formal communication from the NPA itself, but that there is such a decision, I do know.
Right. So now I want us to go to the next case, which is unless there's something else that you think you have left, bar the ruling that the panel will make relating to whether or not you support your version of how you came to authorize the prosecution of Mr. Poison. Bar that, is there anything else you want to say about the Poison matter?
There's just one or two things I want to clarify. Much have been said about the powers or no powers of deputies to prosecute from another jurisdiction to another jurisdiction. And I want to answer this chairperson by saying that we are entitled to interpret the provisions of the NPA differently. But that should not mean that the interpretation that is provided by Mr. Hofmeyer is a Bible and the gospel truth of it. And I'm saying this with all the respect, in the sense that in the NPA, we have always utilized Section 20, subsection 4, and subsection B when we want to utilize deputy directors of prosecutions to other jurisdictions. I think chairperson would also remember that there is a case, which is a very old case. It's a case that involves the former president of the Republic of South Africa, President Zuma. At some point in time, he was together with Mr. Shabar Sheikh. And that case was prosecuted by deputy directors coming from different regions. To date, it is still done by prosecutors coming from those different areas. One of them comes from the Western Cape, and the other one came from the North Gauteng. And there was one at the time who was in KZN. As we speak now currently, the case is still done by that deputy who comes from the Western Cape, and the other deputy comes from the Free State in Bloemfontein. He's a regional head in SCCU. And the other deputy is one of the deputies who is currently involved in the case of Poison. The point I'm trying to make is that we have always utilized that position. And to my knowledge, we have had a successful prosecution and conviction against Mr. Shabar Sheikh. And this objection was never raised anywhere else. And I do know for a fact that Mr. Ngasana did write to the DPP of KZN, that is now Advocate Moiponi Noko, and requested her to explain the basis upon which in law we rely upon in appointing and in utilizing the prosecutors that are not from KZN. And that opinion was submitted to Mr. Ngasana. And if Mr. Ngasana was not happy with the response that he received, he would have withdrawn those prosecutors to protect the prosecution itself. So that if I have acted irregular, this irregularity that I have committed is then corrected. And similarly, Advocate Abrams would have corrected this irregularity if it was an irregularity that I have committed. And I think this irregularity would have emanated from the days of Advocate Bulelani Ngoga himself.
But do you know what the opinion had come up with? Do you know what the opinion had come up with?
Yes, Chairperson, I do. I do.
Yes. And what was the opinion?
The opinion did confirm that the authorization can be issued in terms of section 20, subsection 4B. You see, section 20, subsection 4, A and B of the NPA Act regulates the manner in which a deputy director of public prosecutions can conduct prosecutions. So a deputy director of prosecutions is appointed to a particular jurisdiction. And section 20 subsection 4A then says that that deputy director who is appointed in that particular jurisdiction shall conduct prosecutions in that jurisdiction. And then it says, and. In my vernacular language, it means kunye, and I think in another it means happy. So it then proceeds and says, for any other offenses and to any other courts, the deputy director shall conduct prosecutions upon written authorization of the national director of public prosecutions. That's what the opinion said.
Thank you.
Thanks, Chair.
Thank you, Advocate. Now, I'm going to then proceed and ask questions arising from the NPA's handling of the Mdluli matter.
Yes, Chair.
I think we can take a break at this point.
Yes, I did see her look at the watch, and I thought, yes, she's. Thank you.
Okay. We'll come back within 10 minutes.
Thanks, Chair.
Thank you.
We're supposed to but he was sitting here. Yeah, but obviously, there must be a choice.
before you proceed, Mr. Masuku, just hand down the ruling that you have made. We have considered your request, Ms. Jiba, and applied our minds to it. And we are unanimously of the view that we think you have made your point. You're quite passionate about the way you considered this matter, and the way that you described it was sufficiently graphic. Your description was sufficiently graphic to drive home the point, and we feel that showing us the pictures won't take it further. It is for that reason that we don't need to see the pictures, but we won't do it anyway without the necessary permission of the families. Okay. We need to respect the privacy and human dignity of people, but we did not even go there. I think we are satisfied that the killings were graphic. You described it to us. Thank you.
Thank you, Chairperson. Just following on the ruling of the panel, I want to perhaps give Ms. Jiba the opportunity to at least explain two of the incidents, or pick any incidents out of the number of incidents that you wish to explain, which absolutely turned your view towards ensuring that there's accountability for those deaths.
Thank you very much, Chair, and I really appreciate the ruling that the panel has given. From the day this inquiry was set, I have been very worried and very concerned about the fact that I might have to find myself in a position where I now have to disclose this information in this kind of environment. So I'm really, really grateful for this ruling. Thank you very much. But as Council says, there's just one or two incidents. I'm not going to refer to the photographs. It is just the nature of the evidence I want to take you through. These killings, Chairperson, emanated from the death of one of the police officials, Superintendent Tonto. And Superintendent Tonto was a police official who was responsible for the taxi violence between, there was a taxi violence in KZN between two groups, one called Kamapumulo Taxi Association and the other one called Stenga Taxi Association. And on this particular day, he was transporting one of the suspects to court, and then he was attacked. And it is that killing and the murder that, as a prosecutor, I don't condone the killing and the murder of our police officials. But it is just the manner of bringing to book those that were suspected of these crimes that I am not entirely happy with. The long and short story is that the members then who became the targets or who were suspected of being responsible for the murder of Superintendent Tonto and once Inkosi Zondi were the ones who were then killed by the police. And what really touched me about this case was one day when this presentation was made before me. And I remember Advocate Matenjwa is full of, you know, he would joke when you don't want him to joke. So he comes to me and say, "Hey, Advocate, are you now ready? we are really going to present now this thing to you. And I say, please don't take my time, just present this thing. So he does the presentation, and in the process of this presentation, I learned that one of the now deceased had actually instructed a firm of attorneys, and those attorneys were called Hlapane attorneys. But the attorney who then took the matter is an attorney by the name of Mr. Shezi from the firm, yes. They've written a number of letters to the police to say, we undertake to bring our clients in the event that you need them for anything. We'll bring them before you. Because at that time, the one of the members had already been killed. So which is why then this other, one of the deceased went and approached the court. And the reason for approaching the court was to seek an interdict, interdicting the police from killing the members of Komapumulo Taxi Association. And at the time when he went to court, I think they were already, if I'm not mistaken, they were already plus minus 8 people who have been killed, 8 or 9. I'm subject to correction because I don't have my charge sheet now before me. But those that were killed were the ones that Mr. Shezi has written to the police and say, we undertake to bring these people before justice. We do not necessarily appreciate the fact that Superintendent Tonto has been killed. We hate ourselves, the police the violence which is taking place in cases, but it cannot be right that when you arrest people, when you are supposed to bring them to book, the only thing that happens, there is dead bodies. So this, I won't call their names. So this deceased person, when she made this application for this restraint and interdict, he was the last man standing of those who were suspected of having killed Superintendent Tonto. And lo and behold, the interim interdict was granted sometime in October. And I want to say this, Chairperson, that the person who deposed to the answering affidavit was General Boise. And so, on the armed now with this interim order, and I must assume that she must have felt safe because a court of law had granted some form of protection that prohibited the police from killing this particular person. And that must have been in October yes, it was in October. In November, a final interdict was then issued. I've never seen an order like that, where the order strictly says you are prohibited from killing the applicant. And lo and behold, the following year, in February the 3rd, the very same person who had an order of the court ordering the police not to kill him was killed. And I sat there and I said to myself, I have this evidence, and surely before me, on the basis of this evidence, I must issue this authorization because from where I sit, there are reasonable prospects of a successful prosecution. I could not say that there are none. I just wanted to just say that before I step out of this matter. And by the way, Chairperson, my prosecutor myself, I can take this court and prosecute on my own. Nothing stops me from doing so. Thank you, Chair.
There's something else that is important for how you consider the authorization, and it relates to a document which can be handed up, in which describes which rewards police officers for the work they've done in the killing of these people. Could you please describe to the panel that particular document and the motivation that was made in order to reward the police officers for the work that they had done, which was a killing of these suspects?
If Chairperson can just me allow just to find the document quickly, please.
You may do so.
Thanks, Chair. I've now found the document, Chairperson. This essentially is a motivation to get a performance reward. And as you know, in government, there is a process whereby employees have got to motivate why do they think that they qualify for a performance bonus or a performance reward. So this is a document which is written, is dated 14th October 2018, and it's written monetary and 2008, I beg your pardon, it's written monetary and non-monetary awards. And in the list, those who are requesting this recognition, General Poison is one of the candidates.
So the person requests the recognition and the person must motivate why the person must get the award. You have to you have to motivate it yourself.
You must motivate why
you think.
Yes, you are entitled. Okay. If, for example, I have signed a performance contract currently with the NDPP as a head of NPS, there's my performance contract, it's right there. It states my milestones and everything that I have to do. Now, come the end of the year, of the performance year, I must submit a report and motivate why I think, oh, actually, I've done more than Advocate Mukhadra, who's now a head of AFU. You see, my unit has performed so well, we've reached all our targets, and you must impress your boss and say why you must get this performance.
Yes, I understand that. I think the only question that I had was the fact that you have to motivate it yourself and not somebody else motivates. I understand. So you have to tell, yourself tell what you have done.
Generally, you have to say what you actually have done.
Okay.
Yes.
Yeah, that's different. That's interesting.
Hey, Madam Chair, can I just, for clarity, is this Annex NJ1 to your affidavit that you're referring to?
I'm not so sure how it is now.
Is it the document dated 14th October 2008? Okay.
Correct.
Maybe just for the record, you will find it at 5.132 of the Dropbox.
That one. Thank you very much, Advocate Power.
And what's the date of the document? 14
October 2008.
And hopefully it's being mounted on the computers.
in the document itself is it's now I'm at page 221, but I'm just going to take you just one paragraph. The main motivation as it appears from this document is that these group of police officials should get the performance reward for the killing of the people. It doesn't say that it is necessarily for successfully conducting an investigation that led to the arrests of these persons which are due to appear before court on these particular dates. That's all I wanted to draw the attention of this inquiry to.
Could you please read a paragraph that you're referring to?
It says, during the investigations, it was clear that Superintendent Tongo was a thorn in the side of these criminals who did not hesitate to take the law into their own hands. Investigations also revealed that the following suspects were directly involved in the assassination of Superintendent Tongo. Dumisani Ndlovu was shot by Inspector Kanyile. Lindani Buthelezi was shot by the investigating team. Natim Tembu was shot by the investigation team. Umdu Kolopoto Ntuli was shot by the investigation team, and who was also wanted on a particular case on Mapumulo Cars 02/2 of 2005. Timson Magojela Ndemande and his bodyguard Sibusu Sotembo, who were also shot by the investigation team and who orchestrated the hit in Superintendent Tongo.
Of course, there's a recommendation at the end of the document that they should be rewarded for these matters. Am I correct?
Yes, correct.
Sorry, not matters, but for these killings.
Awarded. Not rewarded, awarded.
They should be given awards for the killings of these people.
Yes, Chair.
Now, thanks for that. Is there anything else you feel the panel should know about the Boysen matter? Are you, other than what you've described? Because we're now going to go to Mdluli and then deal with Mdluli.
Safe to just confirm what has been put to the witnesses, that the case is currently postponed to the 4th of October 2019.
Thank you.
And hopefully on that day the trial will start.
Thank you. Now I'm not going to take you through Mdluli, the General Mdluli. Firstly, I just want to deal with something that I think irritates you, which we must just quickly dispose of. The first one is, do you know General Mdluli?
I know General Mdluli as an ordinary police officer. I know many police officials.
Yes.
I know General Makadlela. I know so many officials.
Is he a friend of yours?
No.
Now, were you on that flight to Durban, which Mr. Roloff testified to?
I was never in any flight that gets paid for out of Secret Services account. I suppose if I wanted a trip and if I was able to get a trip, I would never have chosen a trip to Durban. At least to Mauritius, it would have done better. Okay.
Now, we had evidence from Mr. Roloff, a bundle of documents that he gave us. You had a look at that evidence, am I correct?
Yes, Chairperson.
Was there anything in that document, anything that suggested that you were the person that was being spoken about in the whole document, that in the whole bundle of documents that he was presenting before the panel?
No, Chairperson. I would have expected to see maybe my ID document to a certain extent, maybe a copy of my ID document, maybe a boarding pass, something that confirms that I have received something. You know, these are the things that really frustrate me, Chairperson, because you just don't know how it happens that your name gets used. It's just like this agreasy thing, essential, that we are actually going to talk about. I could never have a situation whereby I allow the money of the state to be utilized. Even when I worked for the DSO as a Scorpions member, the money stayed in the safe. We could all access that money. It stayed there in the safe. It was in the office of my boss. So when you have to go and, because remember the DSO were conducting investigations and prosecutions at the same time. So when you go to consult with a person who's called a source, we had access to lots of money there, generally. So I would never stoop that low and use money belonging to government for my personal use, let alone flying to Durban. Durban is just very close. If I want to go to Durban, I could drive, or perhaps I could fly on my own.
Now, could you maybe explain, in 2007, you did meet General Mrwebi.
Yes.
Would you describe the circumstances under which you met General Mrwebi?
As explained in my affidavit,
Yes.
which I have filed in the labor court, this was in the course of an investigation that was then conducted by the police at the time. And the person who actually introduced me to this whole investigation was the head of the Integrity Crime Management Unit, Prince Mokgoro. Prince Mokgoro, at that time, was headed a unit that looked into our conduct as prosecutors. That's why the unit was called Integrity Management Unit. When I say our conduct, I mean the conduct of prosecutors in general, and perhaps other colleagues as well, that were not necessarily prosecutors, but his focus was generally in our conduct. So in the scope of his work, he must have interacted with the police, because many of the cases that that unit investigated did end up in court. So I want to assume that he must have made or established a relationship with the police in the course of his duties. And he did assure me that there was nothing untoward it. And I did cooperate with the police, yes.
Fast forward to, I think it was 2017, in the High Court. Justice Lehodi and Hughes criticized the handling of the Mrwebi prosecution. You recall that?
Yes, Chairperson, I
Yes.
do.
And you've dealt with that in your affidavits.
Yes, Chairperson, I
And you
have.
stand by what you said in those affidavits.
I do.
Right, but could you just describe what your response is to the criticisms of the courts in the Mrwebi matter?
As you have stated, I have dealt with the criticisms in my various affidavits, which I have filed in court. But I just want to really give a background of my role in how did I get involved in the Mrwebi matter, essentially. As I have stated, I got appointed as an acting NDPP in December 2011. That was after the court had delivered judgment against Advocate Simelane. Then I was appointed to act as an NDPP. That is now 2011. I have nothing to do with the case itself. Then I learned that there were decisions which were made by my colleagues, Advocate Chauke, I think Advocate Mrwebi, Advocate Mrwebi. It was relation to the fraud and corruption charges and all of that. I was overwhelmed by the position, I must say so, as an acting National Director of Prosecutions. To head that institution is not a child's play. It's a huge institution with a lot of responsibility. So I think it was just before the meeting that we held on the 24th and 25th of January 2012, yeah, that I just requested a briefing from both of them. What is happening with this case? So I got that briefing. And I was made to understand by Advocate Mrwebi that indeed the only reason why he has withdrawn these charges is because there was no evidence at the time when he looked into the docket that connected Mdluli to the crime. Because the evidence that he had, that he had in the docket was an evidence that connected somebody else. I think Mr. Barnett. And the understanding was that the case would be enrolled in the future once the investigations that he has directed are actually finalized. Now you see, Chairperson, we withdraw cases all the time when we are not satisfied that the evidence is sufficient. And for me, there was nothing untoward this actual explanation. And so my understanding was that the investigations are now continuing. And I was even informed that Advocate Breitenbach has been told that she must now ensure that she guides, we use the word guide, he guides the investigation and the prosecution so that the case can then be quickly enrolled before court. But then, I think at the time, there were also issues surround an investigation that emanated from the complaints of Mendelo, which were received by Advocate Simelane long before I was appointed to act. And I got to know about them because as Advocate van Rensburg came to give me a briefing about that and that the investigations are continuing and all of that. But I didn't connect the two at the time. The investigation against Advocate Breitenbach and also the case now against Mdluli at the end of the day, which has been withdrawn. I then received, I think, a memorandum which was dated the 24th of April. When I came back from leave, I had taken leave, and I think that leave form can be produced here if the inquiry so wish to see it. I had taken leave, and when I came back from leave, then I meet this document. I think my PA at the time was Miss Madzi, but equally, she was not in the office when this document was delivered. She received it from one of the staff members in the NPS, because there's a lot of support staff in the NPS. So she received it. She received it then. So I read the memorandum, And one thing that did not make me happy about this memorandum, and I want to say this here, I wasn't happy that the memorandum is addressed to everybody and yet is for my attention. If you are raising something with me, there's no reason why you must copy to everybody else who's not necessarily going to assist with whatever you are trying to raise here. So I took exception to that, you know, I'm not following what is this process. And secondly, I could not understand why this memorandum, because I am informed that there is an agreement which was reached to the effect that, please, by all means, once you are done with this process of collecting this evidence, to ensure that the case, when it does get enrolled before court, we have a successful prosecution. I'm not understanding why would the prosecutor now write and make these submissions? Because nowhere am I being told that the evidence has now been obtained and all of that. I can't remember whether it was Advocate Mrwebi who actually came to me, or it's me who called him, but in any event, we met over the memorandum, and he did confirm that he had received it, and that he had spoken with Jan Ferreira, because he could not have spoken with Advocate Breitenbach at the time, because Advocate Breitenbach was now on suspension at that time. So now we meet, and he emphasizes that, you know, he can't understand what is the difficulty in this, because all that he's trying to say is that, colleagues, we are going to lose this case because you are going to lead evidence that does not link this particular person. And he has even advised them that, why don't you perhaps approach this other person and make this other person a Section 204, so a witness in terms of Section 204, so that we now have evidence that is strong against this one. Because from what she explained was that in the way things have been done, the hands of this one were clean, essentially. He has managed to keep his hands clean. So we had a suspicion that perhaps they were doing this thing together, but now you don't have evidence that you are going to call to actually show the link between the two of them. So that is what I get. Then I say to him, okay, that is fine, but please, you know, all of this doesn't really help me. All I want to see is a case that is properly investigated and before court, and that's about it. And then I leave it at that. Here in the inquiry, I think there is a letter that, I don't know whether it's in the, it was produced by Colonel Rolofse or by General Dramat, I can't remember, but there is a letter that emanates from my office. And the letter is written by Ms. Jekili Pinka to General Dramat, to the effect that this matter is dealt with by Advocate Mrwebi, or something to that effect. I have never seen that letter. You know, and I felt so bad because General Dramat is a very nice person, essentially. And I realize now that he had a challenge that he thought that he has addressed with me, yet I had not received it. Part of the challenge was that in the office of the acting NDPP, I worked in this fashion. I found the support staff that was in the office of the NDPP, and they had tasks. So there was a corporate manager, and there was an executive manager support, and other people. But then the executive manager support, Ms. Lipinga, was responsible for documents and document management. So because I could not be able to read all letters and all correspondence that comes to the office of the NDPP. We had a system, that is a system that I found there. We had a system whereby if something requires the attention of asset forfeiture unit, you just write and refer it to asset forfeiture unit. If a matter requires the attention of the NPS, then you refer it to the NPS. So what must have happened here is that she wrote to Mr. Dramat and responded. And I regret indeed the fact that she did not then bring that letter to me and all of that. I think what she only saw was that, oh, this matter is dealt with by SCCU. Let me direct that it should be dealt with by SCCU. But in any event, when we then met with General Dramat, I spoke with him and I also said to him, but General, we meet in all the meetings. I mean, we attend the JCPS cluster meetings together all the time. And if there was this kind of a problem that you say you were experiencing and you were not happy, why didn't you just talk to me? We are sitting in the JCPS cluster, and sometimes as members of the security cluster, we would take a position at defending ourselves against the economic cluster, because there was a tendency of the economic cluster wanting us to solve their problems as the JCPS. So we had a particular relationship. Anyway, so back to this memorandum. I've stated in my affidavit that, frankly, I did not consider Advocate Breitenbach as a relevant person as defined, as stated in the Act. Precisely because she is a person who must make things happen. It is in that context where I said I did not recognize her as a relevant person. She's the one who's supposed to assist in ensuring that this thing gets enrolled in there, the case gets proceeded with. And I'm not sitting here proud that the case has not seen the light of the day today. There were times, Chairperson, that I was tempted to arrange a meeting between the National Commissioner, just to understand what is this stalemate, so that they can explain to us what are the issues, why can't they assist? Why can't they assist to ensure that we get these documents? What can we do? But then I was constrained. I was constrained by the fact that there is this litigation against me. I don't want to appear now as though I'm interfering with this case and all of that. So that's generally what happened in the case itself. And as you notice, Advocate Mzinyati himself was not aware that the case is in his office, because it's dealt with at that level by prosecutors.
You've mentioned this memorandum, because this memorandum occupied a bit of space in the evidence of Mr. Ferreira, Advocate Ferreira and Breitenbach. Did you deal with the issues that were raised in the memorandum nonetheless?
I dealt with them, and I dealt with them because I must tell you that Advocate Mokgoro was neither pleased himself, because I said, you must take me through, because I want to understand, you know. And when we get to that stage, we start calling each other with the clan names, as you have heard, Mzinyati, I would say Bele, I would say, hey, Mzinyati, Mzala, or something. So we start going there, say, no, take me through to this thing, I want to understand. So I was quite satisfied, and I had no reason to doubt the competences of Advocate Mrwebi. He is very, very, very experienced. As you have heard from his CV yesterday, he's been in the prosecution service for quite some time. I don't associate myself with those who think that he is not competent. He's very competent.
Thank you. Mr. Ferreira was not happy that you did not come back to him about the memorandum. What is your response to that?
Well, I might not have come back to him, but I but I did have a discussion with his supervisor, and really, I didn't see the need to come back to him because I've communicated with supervisors. We have protocol in the institution. So I expected that perhaps Advocate Mrwebi would have spoken with him, because basically that is his first point of call.
Thank you. Now I'm going to move to another court case, which the spy tapes matter.
Before you move, sorry, Chair, before you move there, you know what is worrying about this case, this whole case of Mdluli, is that there seems to be something I don't understand, something that just prevents it from seeing the light of the day in a court of law. I do remember that at some point in time, Mr. Ngasana appointed a team of prosecutors himself, after I also had appointed a team of prosecutors that was led by Advocate Baker, a very experienced commercial crime prosecutor who's late now. Very, very experienced prosecutor. And I had reasons why I wanted him in the case because of his experience. We worked together in the Office for Serious Economic Offenses, which is called OSIO. And we were led there by a very brilliant chap, Dr. Jan Swanepoel. So we knew exactly what we were doing when it comes to the field of commercial crime. We would never, never, never enroll a case unless we were certain that we have evidence linking a person to the crime. And I'm proud to say, when we did take a case before court as OSIO, we had accused begging us for us to accept a plea of guilt. And I sometimes wonder, where would we be, Chairperson, if that unit was allowed to remain on its own, with all the corruption that everybody is now complaining about? Because there were expertise that we lost from that particular organization. We lost people like Dr. Jan Swanepoel, who were passionate about the prosecutions of commercial crime. Not everybody likes to prosecute commercial crime. It's not a very easy case to kind of deal with.
Thank you for that. But so I was going to now move to the I would call it the FUL matter, the spy tapes. It's the DA matter. Am I correct?
Yes.
Yes.
Chairperson.
Now you were also criticized in that case. Am I correct that case is one of the issues that are serving before the Constitutional Court at the moment?
The spy tapes?
No, the criticisms that were leveled against you in the spy tapes. You recall those criticisms?
Oh yes, Chairperson. Yes.
Yes. What is your response to those criticisms? And bearing in mind that you've already dealt with that in your affidavits.
You know, I have Advocate Power to thank for that case in obtaining the memorandum that she did obtain from Advocate Paul Kennedy. Because you see, at the time when those criticisms happened, I was like, but I was acting on advice with people. I did not just make these decisions by myself. And bear in mind that this is a case that I found in the NPA. Decisions have already been made on how the defense against the production of this record is actually going to be made, and all of that. So the only thing that I did was to ensure that we continue with the approach that has already been adopted. And part of the reason why I'm criticized in the SCA. Part of the reason why I did not want us to get involved in the battle, if I can call it the battle, in the issues between the DA and former President Zuma, because I knew that this is not a kind of case that is going to come to an end anytime soon. So in my reasoning, I was trying to protect the NPA from something that says that, yeah, you see, the NPA is now unfair to me again. And I know for a fact that there is now currently an application for a permanent stay. And whatever can be referred to in that application for a permanent stay, which fortunately my council is part of, whatever can be raised in that application for a permanent stay, nothing can be said about our conduct as the NPA further. It can be based on anything, but not on our conduct as the NPA further during my time. So those were the things that I was guarding against, which is why I was happy with the advice that Advocate Kennedy had actually given.
Now, there are a number of witnesses that I would like to whose evidence I would like to go through with you. In fact, what I've done is I'm going to deal with these witnesses with these witnesses in accordance with the gravity of allegations that they make against you. And the most difficult allegations that are made firstly by Advocate Breitenbach and Hofmeyer. And it is in relation to your experience for appointment to the position of the Acting National Director of Public Prosecution and your current position. Essentially, both Advocate Hofmeyer, Mr. Hofmeyer and Advocate Breitenbach their evidence was that they did not believe that your elevation or your promotion to the position of Acting National Director of Public Prosecution was justified. What is your response to that? Having regards to your CV, which I now tend to.
I would not understand why they would feel that, firstly, I was never entitled to be promoted to the position of a Deputy National Director of Prosecutions. Before I was promoted to this position, I already had about 17 years in the NPA. So that is huge experience for anybody. And as I sit here today, I have got 27 years experience in the NPA, having worked through the ranks.
Yeah, just so I can just lead you through the CV you have, you've provided the panel with. You firstly, I mean, you worked as a prosecutor in the Eastern Cape, Pedi, Tsolo, and Mthatha. What was your experience there? Because that must have been interesting to work in those kind of courts.
That is why, Chairperson, I'm very passionate and protective of the prosecutors, because I started right there. The environment there is still the environment today in some areas. It's kind of a space whereby we used to compete about a desk and a chair. Depending on who arrives first, then that person is going to get a desk and a chair to sit upon. So those were my humble beginnings, where on a Monday morning, you are faced with so many dockets, assault common, drunken driving, and all kinds of cases. And then you graduate. What did you touch?
Possession of dagga.
Definitely, Advocate Homozo. So you're faced with all of those kind of cases. You don't even have a room where you can safely say, I'm now going to consult. You don't have those privileges at all. And when it is a knock-off time or child time, you are going to be in the same taxi with the very same people that we're actually prosecuting. And maybe tomorrow the case is postponed for sentence, but you are in a taxi with those particular people. So, before you can sit in your office, you probably have to first sweep the cow dung, because the cows or whatever, they were sleeping there in the office. So I have an understanding of the difficulties that our prosecutors continue to face in some particular areas. So I come from those particular humble beginnings. So it was better when you were then in the regional court, because then in a regional court, the case first is referred to you. Everything has kind of been done for you. So you are now this prosecutor who's now in the regional court and all of that. So I come from those particular experiences, yes.
Yes, and then you were appointed. Sorry, you then served articles with Kunta Nsebeza attorneys in 1997 to 1998, and then you also worked 1 year at Deloitte and Touche as a senior forensic consultant.
Yes.
Do you want to share your experience working as a senior forensic consultant?
I didn't spend much time there, but I was fortunate when I got there. We were led there by Robert Cameron Ellis, a very expert and a senior person in the forensics field. They were dealing with a particular case. I don't know if I'm free to, but I don't want to mention the names of the people in the inquiry. But it was a case that occupied the media at the time. There were thefts of lots of monies. It is there that I actually got to understand what accountants do to weaken our case as prosecutors. Because remember, in the environment of commercial crime, then we will have issued this mandate with the terms of reference and appoint a particular forensic company so that they can lead evidence as an expert. In this instance, we were supporting the defense. You know, they look into the nitty-gritties of everything. The invoice itself, how is it generated, and all of that. So I got to learn there that it's very important when you deal with these particular cases also to have that mind that this thing can actually be challenged. So if not able to prove its origin, you're not going to even be able to hand it in before a court of law. But as counsel would see, I didn't spend much time because I didn't get the vibe of the actual activity which happens in court, because then as a forensic consultant, yours is to investigate and kind of obtain statements, do analysis and all of that. So that is why I then left Deloitte and Touche.
Yes, and then you were appointed as a senior state advocate with the Investigative Directorate for Serious Economic Offences in 1999 to 2000. And then you were appointed as a Deputy Director of Public Prosecutions in 2001 to 2010. What did your job entail? Firstly, I mean, if you want to say something about your position as a senior state advocate and as a Deputy Director of Public Prosecution, please do so.
The good thing about being a senior state advocate in the then Office for Serious Economic Offences was that you had a cushion. You had your deputy who was there to guide you all the way. We had a very good system in Ozio where you were never alone in court. You always had your deputy on your side. So Advocate Becker was one of the deputies that I worked under. But the strange thing in that is that because before we would take any case before court, there would be presentations of those cases. And even your deputy that you thought that you were working with will be fielding questions like you were not together in this case. So we had something called like a moot court preparing us to present cases. So the good thing was that you worked under guidance. And so when I was promoted to the position of a deputy, it was then my turn to guide the senior state advocate. So that was the difference in essence. The roles have changed. I have a team of senior advocates that I'm working with, that have assigned projects, and senior special investigating officers that are working with these senior advocates in ensuring that the projects that have now been authorized in terms of section 28 subsection 13 or 28 subsection 1 of the NPA Act become cases that are actually presented before court. Yes.
And you handled some of the most, or could you tell the panel some of the cases that you handled when you were a deputy director of public prosecution, or when you were a senior state advocate? Any of the cases that you think you should share with the panel that demonstrates your experience in the actual field of practicing law?
There was one case that was really rotting, in the sense that there was a little bit of no movement in it. And that was when there was the beginning of all of these things called Ponzi schemes. And then later, they were called then pyramid schemes. You know, in the pyramid schemes, there will be all these brochures that are developed, and they would look very genuine. You invest this much, and then you are suddenly going to get rich. You're going to get the percentage of interest will then be so huge. That is something that you will never even get from any bank. So that was the case that I took it through, and we were successful in the sense that we did get a conviction and sentence. And those, what we did, we took everybody who was used as a runner in marketing the scheme, and we used them as witnesses against the masterminds behind the scheme, because then they were enriching themselves at the expense of the people. So depending at what stage you join this scheme, then you are going to be able to bear the fruits and get the profits. But for all of those who are joining later, the money is no longer there, because the directors or the managers of this particular Ponzi scheme have now used the money for their own benefit. So we got some good convictions and sentences of 15 years in that case. Yeah.
Sorry, because it's a case that's probably in the public domain, do you mind mentioning the name? Just.
I don't think it got, it was in the public domain. It was a case called Sun Multisave.
Sun Multisave.
Sun Multisave. And the other case that really, where I worked with Mrwebi was a case that involved the strategic fuel fund, corruption in the strategic fuel fund, and we dealt with that case successfully with Advocate Baker. So those are just a few cases, yes.
And then you were appointed as Deputy National Director of Public Prosecution in 2010. I'm tempted to ask you why you were appointed for the position, but I think you perhaps I should actually. Why do you think you were appointed to the position?
Maybe because I don't know, Chairperson. I
It must have
wouldn't know
been experience.
why I was appointed, but I was glad to be appointed so that I could be able to make a change in the way that I think I have made a change in the way in which we run prosecutions, and particularly focus on service delivery and performance generally in courts. Yes.
And what were your responsibilities in that position?
As a Deputy National Director, in particular in the portfolio that I am assigned to. I keep on going to this portfolio and then I get to another portfolio. But I've spent time in this portfolio now as a head of the National Prosecution Service. The National Prosecution Service consists of all directors of public prosecutions that are in the regions. My primary responsibility is to ensure that there is performance. How do I then ensure that there is that performance? We have systems that we have put in place in terms of which we measure our performance. We have performance indicators that we have developed, and I must be proud to say that the judiciary has taken some of our performance indicators that we used. And in fact, I do recall that when I was acting as an NDPP, I had an occasion where I went with my operations management team to see the Chief Justice, and we presented the various performance indicators that we use to measure the performance in our courts. And he was quite impressed with that. But at that time, we're seeking his assistance, that we really want to ensure that we don't spend less hours in courts, because if you spend less hours in court, then you're not going to have production. So we wanted a buy-in, and that culminated to the establishment of a structure which is called the now NEEC.
Stands for National
Efficiency Effective Committee.
Yes.
And that structure consists of everybody who has got something to do with court performance. There are advocates, there are attorneys, there's justice, there's public works, there's just everybody. So basically, my responsibility is to ensure that whilst we have created these performance measures and performance indicators, I hold the directors of public prosecutions accountable as to why in that court in Tsitsikama, it certainly looks like there is nothing that is happening there, because the cases are particularly not even finalized, or we're not meeting our rates in terms of the conviction rates. Why is that so? So we sit in meetings, we have a structure that we call the National Operations Management Team.
And in your capacity as Deputy National Director of Public Prosecution, you've undergone performance assessments. Am I correct?
Yes, Chairperson.
Would you like to share with the panel what those performance assessments say about your work?
It's a pity I do not have before me, but I would have wanted to start with my performance assessment as an acting NDPP.
Yes.
As an acting NDPP, I was rewarded for my performance. I think I've submitted the annual reports that I presented before the portfolio committee, because the focus, my focus, was really to ensure that we deliver what we're supposed to deliver to the people. Because remember, Chairperson, I was there. I know the pain of a gogo who does not even have money to take a bus or a taxi to court to ensure that that case is being done. So I was very passionate about the fact that we need to do everything in our power to ensure that those cases that are before courts are finalized. So it was because of the systems that I had put in place that I'm sure when I motivated from my performance reward, I was then rewarded as such. It was a nice money in my account, yes.
Yes, that we would all want that, isn't it? Now, then there was also perhaps I should just take you through the evidence of Mr. Hofmeyer, which I think, or perhaps we should take a comfort break.
Oh, you saw me look at my watch. Yes, I think so. We can take a comfort break for 5 minutes. It's enough, no? For 5 minutes. Thank you.
Thank
Half. If you want another break, it will be 2.5 minutes.
One check, 1 2 1 2 1 2 1 2.
Thank you. Mr. Masuku, we are in your hands.
Thank you, Chairperson. I indicated that I would be now focusing on what I consider the most damaging allegations against you by Mr. Hofmeyer. They are set out in his affidavit. And what I intend to do is to just take you through the paragraphs of the affidavit that I believe warrant a response. If you, perhaps you should have the affidavit in front of you. The affidavit of the 25th of January 2019 of Mr. Hofmeyer. But I just want to start off firstly by asking you just general propositions that come through his affidavit. And I will pick the one in paragraph 34. He says the NPA and prosecutors must not only be independent, but must be seen to be independent. Do you agree with that proposition?
Yes, Chairperson.
And he says, from a prosecuting authority to be successful, for a prosecuting authority to be successful, it has to be credible and trusted by the public. The public will only trust the prosecuting authority if they believe that it is prosecuting well and independently. Losing this trust carries the serious danger that the public may resort to self-help and vigilantism. Do you agree with that proposition?
That's possible, yes, Chairperson.
And then he says, trust and credibility is essentially important in relation to difficult decisions where there is considerable evidence, but the evidence is not sufficient to satisfy the legal requirements to institute a prosecution. That's not a controversial proposition, right?
No, it's not.
And then he,
Sorry, could you give us the paragraph numbers as you read out the
paragraph 38 now. I'm in paragraph 38. I apologize. No, I've moved the cheese. Then in 38, he says the abuse of prosecutorial powers to advance political agendas has been one of the issues that have impacted most severely on the perception of and public confidence in the NPA. What do you say about that statement?
It's a very, I must say, it's a very reckless statement, in particular if you do not have any evidence to substantiate the allegations that you are actually making, especially as a senior leader of the institution, in an affidavit and in an inquiry of this nature. It's a statement that really saddens me in particular.
Yes. And then you would agree with the statement that says, thus in paragraph 41, thus to maintain the confidence of the public, it is particularly critical for leadership to be seen to be beyond reproach.
Certainly.
And then in paragraph 42, he says, it must also be seen to be acting on allegations of political interference, as these cannot be tolerated and must be harshly dealt with. You agree with that?
If they are, yes.
Right, but with listening to Hofmeyer, did you get the feeling that there was evidence to support that particular allegation?
That is why I'm saying for the beginning that, you know, the kind of these statements really are particularly reckless, especially if they come from a senior leader of the institution like myself, like Mr. Hofmeyer, and perhaps like if they would come from Advocate Mukhatla, they would come from Dr. Silas Ramai. Those are the people who are at the top echelons of the NPA and the National Director of Public Prosecutions. You wouldn't want a situation whereby you make such statements, because those statements really begin to say something to the members of the public, and as a result thereof, they might lose confidence in the institution, and yet there is no basis The only case that I know of where there has been this political interference as alleged by Mr. Hofmeyer himself is the case that has now been decided upon in the SABC. This is the case that we refer to as the spy tapes. And this political interference in that case came from his own analysis of the telephone conversations between various people, and that is the only case that I can perhaps say I know of. Other than that, I do not know of any case where there has been political interference, as he alleges.
And then in paragraph 43, he says the NPA should never be seen as an extension of any political party or to give effect to its agenda. As a principle, you agree with that?
I do.
And then in paragraph 44, he then says, even more dangerously, in a number of prosecutions, the NPA has essentially been perceived to be acting on behalf of a faction of the ruling party, such as the prosecution of those who were opposed to the majority grouping in the ruling party at the time. An example is the prosecution of Kodan. I suppose he's referring to Minister Kodan. What's your comment on that?
I do not know which faction of the ruling party that Mr. Hofmeyer is referring to, that the NPA apparently ascribed to. What I do know is that before a decision is made to prosecute anybody in the country, we are guided by our policies and our policy directives that Dr. Ramayide, as a first witness, addressed us to. So whether you are a well-known criminal, the worst of them all in the country, that will not necessarily influence us in a particular case. What we ought to look at is evidence that is presented before us at a particular time involving you. So it matters not who you are. So I really take a strong exception if Mr. Hofmeyer then is saying that as an institution we seem to be taking a particular side of a political fraction or faction as he states in the affidavit.
He gives the example of the prosecution of Minister Kodan. Can I ask you this? Do you know what faction Minister Kodan belongs to?
No, I don't know which faction. I don't even know that he's in a faction. So I wouldn't know which faction he belongs to.
But more importantly, did you take any decision in relation to the prosecution of Kodan?
No, Chairperson. At the time when a decision was taken to prosecute Minister Kodan, I was on special leave. So I was outside the NPA. I do recall that there was that decision was made.
And then in paragraph 45, he says the NPA also played a leading role in getting rid of those in law enforcement who were prepared to do their job properly. And then he gives examples, the prosecution of McBride. Do you know McBride?
I know him as a head of IPED.
Were you involved in his prosecution?
No.
Do you know Mr. General Tramat?
Yes, I know General Tramat.
Were you ever involved in his prosecution?
I was not involved in his prosecution. The prosecutions, you must understand this. The decisions to prosecute are not made at national office from our ranks as deputy national directors and as national directors. The decisions to prosecute are made by prosecutors in various divisions depending on where the case is. I can tell you about the decision, for example, in Tramat, the General Tramat. The only thing that I know of about the case is that he made representations. Now those are representations. Representations in their nature are dealt with in our office. That is now at national office from the Director of Public Prosecutions Office. But these representations were dealt with by Advocate Mzinyati, and I know that the representations were accepted. So that is the extent to which then we start getting involved at a national office. So none of these prosecutions that are indicated here did I take a decision to prosecute, because I cannot make a decision to prosecute on these particular cases. As I've stated to you, they are made by prosecutors.
Except for the Boyson decision, would you say when given what you know about General Boyson, would you say that when you issued that authorization for him to be prosecuted, you were getting rid of someone in law enforcement who was prepared to do their job properly?
No, Chairperson, I would never do that. I don't even know General Boyson, for that matter.
In fact, in the next paragraph, 46, Mr. Hofmeyer says, in the case of Boyson, I believe that the racketeering authorization was not proper in this case. It certainly had not gone through the normal quality assurance process in the NPA, which included all such charges being vetted and approved by Anthony Mosing and Elijah Mamabolo, who served on the organized crime desk in the office of the NDPP.
I have already explained the process that is followed in the NPA, but of interest in what Advocate Hofmeyer is saying, he says that they have to be vetted and approved by Advocate Anthony Mosing.
Yes.
And that's exactly what happened.
Yes. And then the further allegations that are made, which I would like to deal with, which are set out in paragraph I beg your pardon. Yes, in paragraph 106, there he deals with what he refers to as assisting Selebe in his attempts to frustrate the DSO investigation and prosecution. You've dealt with that, but is there something you'd want to say a bit more about that allegation, that you assisted Selebe, who was the National Commissioner, now deceased, in his attempts to frustrate the DSO investigation and prosecution?
My cooperation with the police in a lawful investigation that they were conducting at the time, I cannot deem that as assisting Selebe. I've never assisted Selebe in anything. I don't even know. I didn't know. Was it a general? What is it called? National Commissioner Selebe.
Yes.
I only knew him like everybody else. I mean, he used to appear on TV. That is the extent to which I would know him, but I've never even met him as a person, like I have met you as my counsel right now. So I don't even know where he stays, for that matter. So I don't know Selebe.
So in the case that he refers to, it's a 2007 case. Is that not the case where you were then subjected to a disciplinary hearing?
Yes, Chairperson, that's the case.
Okay, could you perhaps share with the panel how that process unfolded?
There was a disciplinary process that was set up in place by the NPA, and naturally I lodged a process in the labor court at first, which I lost. And then I lodged another process in the labor court in terms of the Protected Disclosures Act. And indeed, an interdict was granted there by a judge. I have the interdict somewhere in my Judge Tele. Judge Tele, I can't remember which judge, but it's in my documents that I've provided counsel with Che. And as a result of that interdict, because the interdict was against the Minister of Justice and the National Director of Public Prosecutions, Then we engage in settlement negotiations with the then acting National Director of Prosecutions, Advocate Mshe, which resulted in a settlement agreement signed by myself and Advocate Mshe.
Yes. Now, having regards to the affidavit that you were asked to file in that case involving former National Commissioner Silebe, would you say that that was I mean, did you mention any names of people in that affidavit?
I did not file an affidavit in the matter of former National Commissioner Silebe.
Yes, you're correct.
I only filed a statement. I gave a statement to the police who were conducting criminal investigations against Advocate Kharinel.
Yes, I apologize. I think you're correct. And then I want to go to paragraph 122. If you look at that paragraph, you've answered most of the allegations there, but Mr. Hofmeyer says that he titles it the wrongful prosecution of poison. And then he says a very concerning development trend that emerged under Jiba and was almost institutionalized by Abrahams was to prosecute those who were perceived as obstacles to corruption and the capture of the state. This included particularly persons in law enforcement such as Breitenbach, Dramat Sibia, and McBride. We have answered the questions relating to those, but is there any comment you want to make about this very damaging statement?
The statement really is very damaging, because once a person says wrongful prosecution of somebody, that exposes you to a lawsuit, because now says it is a wrongful prosecution of someone. I have already given and the nature of the evidence that was presented before me, which led me to the institution of this particular prosecution. So I don't believe that there was anything, and there is anything wrongful in the authorization of the prosecution. As I have indicated, I had nothing to do with the decisions which were made by prosecutors to prosecute the other persons mentioned in this paragraph.
And would you, knowing what you know, and having seen the evidence that you have seen, would you say it is correct factually that the prosecution of General Poison is perceived as a prosecution of someone who is perceived as an obstacle to corruption and the capture of the state?
Ms. Jiba, can you just speak up? Apparently, people at the back can't hear you. Thank you.
The Chairperson, I wouldn't like to speculate, really. All I can say is that on the basis of the evidence that was presented before me, I found it justifiable that I must institute an authorization.
Yes. And then he says in paragraph 123, the first of these cases was the attempt to prosecute Johan Poison, the head of Hawks in KwaZulu-Natal, who had lodged investigations into corruption in the province, including the corruption case involving two senior ANC politicians, MECs Peggy Nkonyeni and Mike Mabuyakulu. You see that?
Yes, Chairperson.
Did you know what General Poison was involved in? Did you know what investigations he was involved in when you authorized the racketeering charges against him?
I have no knowledge of what investigations General Poison is involved in at all. I wouldn't know that.
And then he says that he had exposed significant corruption and the AFU worked with the Hawks to seize assets in both matters, so I became very familiar with the facts of the case. Do you know anything about that?
No, Chairperson, I don't.
Then he makes the allegation that he submits that the charges laid against Poison was an attempt to remove him from office, or at least to ensure that more pliable acting head would be appointed in the place, in his place who would close down the investigation. What's your comment on that?
Certainly, when I instituted a prosecution against him, I had no such intentions.
And then in paragraph 126, he says, I refer particularly to an opinion by the prosecutor in the matter, Jan Ferreira, setting out in great detail the evidence against Jiba, and that were sufficient grounds for her prosecution. Yes, I am informed that the inquiry is in possession of this opinion. We've dealt with Advocate Ferreira's views.
Yes,
Do you want to add
Chairperson.
anything?
Yes, Chairperson, we have dealt with the Advocate Ferreira's views.
And then he, in paragraph 150, he says the following cases were, he says other cases that followed under Abraham's. Is there anything you want to do you want to deal with anything that has to do with Advocate Abraham's that is referred to in that paragraph?
Safe to say, I wouldn't be able to speak on behalf of Advocate Abrams, but safe to say that the procedure is, as I have indicated, that decisions are made by prosecutors generally to prosecute anybody. We get involved at a stage whereby there is an application for a review. So that is all that I can say.
And then in paragraph 151, Mr. Hoffman accuses you of refusing to cooperate with Ngasana as NDPP and to provide reports on her work and the cases against her. And then in brackets, insubordination. As you read in paragraph 151, it says, when Ngasana was appointed as NDPP, he requested Jiba to provide him with reports on various cases which had caused public controversy at the time. In paragraph 153, then he says, she refused to accede to this request and simply refused to do so. This may amount to insubordination.
I have dealt with this and I've explained myself in the affidavit that I have filed in the GCB matter. Just to repeat what I've said there, these were not ordinary circumstances that we were dealing with in the NPA at a particular time. I knew for a fact that all these requests were not ordinary requests because the reports were submitted to the former NDPP, Mr. Ngasana. The reports were submitted by those that were responsible for making the decisions, who understood the process better than and what the intricacies of the cases that they were dealing with. I knew there were attempts to get me out of the institution, so I did seek legal advice. I sought legal advice, and the advice that I was given was that because you do not know the intentions, you are not so sure of the intentions in which these reports are now requested from you, especially that the reports are there already, they are with him. So the advice that I got was that I should not provide any response. And lo and behold, immediately after all of these reports that were requested, at some point I was hailed before a criminal court. I was made a criminal and I was charged for an offense. There were applications by the GCB to have my name struck off the roll. Pursuant to all of this.
Can you, the criminal case that you say you were charged with, what criminal case was it?
The criminal case emanating from my decision to institute a prosecution against
Poison.
General Poison, yes.
Right. And do you know how the GCP got involved in your striking of application?
Except from what I heard from Advocate Karen van Rensbeck, when she testified when she testified in here, that is when I actually got to get the detail of it, that there were councils who were briefed, they gave opinion, and after these councils were briefed, then the NPA approached the GCB, and basically the GCB got involved at the behest of the NPA.
Right.
Yes.
Now, in paragraph from paragraph 154, it's under the topic refusing to cooperate with the Yakub inquiry. I assume that it's former Justice Yakub inquiry, and then insubordination. In paragraph 154, he says, when Ngasana was appointed as NDPP, he requested all of us to cooperate with the inquiry. He requested Jiba to provide the inquiry with reports on the various cases which had caused public controversy at the time. She simply refused to do so. This led to the appointment of the Yakub inquiry. But again, she refused to comply with a lawful instruction by the NDPP to cooperate with the inquiry. I believe that this may amount to insubordination. What do you say, Wilbert?
The process of cooperation with the with Judge Yakub's inquiry was a voluntary one. Nobody was forced to cooperate with the Yakub inquiry. But just to put this in perspective, we were told that the purpose of the Yakub inquiry was to investigate media leaks. Nothing more. And then later on, it emerges that the purpose of the inquiry is exactly to investigate my conduct. And I mean, I've been working in that institution for a number of years. I know the process that should be embarked upon. This is the process that should be embarked upon. If there's any complaint or conduct that is complained of against me, this is the process where I am supposed to account for my conduct.
Yes. Then in paragraph 155, Mr. Hofmeyer says that he accuses you of not dealing with Mrwebi regarding the in-consultation issue. He says when she was acting NDPP, Jiba failed to take a firm position on this issue. And as far as I'm aware, no attempt was made to sanction Mrwebi for his refusal to accept the correct meaning. Instead, the EXCO meeting quoted above, he was allowed to continue stating that this is interference with his powers, as well as at the later SCCU strategy meeting. What's your response to that?
I don't know in what way did Mr. Hofmeyer want me to deal with Advocate Mrwebi. Chairperson, you must understand that at the time, and in the history of the NPA really, there was no compliance of this particular provision. As we have heard from the testimony that much of Advocate Chris Jordan. If you read the minutes that Willie Hofmeyer has referred to, in those minutes, there is a paragraph or a sentence where I think there is a resolution which is taken to the effect that there should be Dr. Ramayite together with Advocate Mrwebi must then establish a system where the special units will then work with the DPPs so that we then enforce this particular provision. I was not about to recommend and write to the president, if that's what Mr. Hofmeyer expected, write to the president and say that an inquiry should then be held into the fitness of Advocate Mrwebi, precisely because the general practice in the NPA has never been that this particular provision is complied with. It was sufficient that we have now dealt with it. It is now in his head that he now knows that as a special director for SCCU, and in fact all of them as special directors, because he's not the only special director, there are other special directors, they now know that they must comply with this, which is why there were regulations that were then drafted to ensure that there is a process that is then followed. So much so, I have dealt now recently with the cases where there was a disagreement between a decision of a DPP and the decision of a special director when they were doing their in-consultation process. And the way in which we deal with right now, rightly or wrongly, but the way in which we deal with it, once there's a disagreement, we get both of them. That is, the special director will write his reasoning as to why he is saying the case must go like this, and the DPP writes his own reasoning, and then the NDPP then makes a decision. So that is how we now deal with this process.
And then from paragraph 160 to 165, Mr. Hofmeyer says that in response to your paragraph 24 of your answering affidavit in the GCP strike of application, he says in this paragraph, in paragraph 161, in this paragraph, she states that the prosecution team has all been adamant in briefings to the NDPP that they had a strong case against poison. And then he says the last briefing was on 21 May 2014, where the ex-co members of the NPA were present. I have checked my records and can find no record of such meeting on that date. I cannot recall receiving any such briefing. And then he attaches minutes and a log, action log. Do you have any comments on that, on those paragraphs?
I am here now, Chairperson. I don't have access to the minutes of the NPA, but if I were to be allowed to do so, probably I would find these minutes. But suffice to say that the prosecution team is no secret, has always been adamant, and it is still adamant, that they have a strong case against General Poison, which is why last year, towards the end of the year, Advocate Mayema and Advocate Matenja were in court to oppose an application to have the case struck from the roll, which is what resulted from the case being postponed to the 4th of October 2019.
Right. So, and then, of course, if you look at paragraph 161, in paragraph 61, he summarizes your paragraph 24 as saying that the prosecution team has all been adamant in briefings to the NDPP that they had a strong case against poison. But in the next paragraph, it then says the last briefing was on 21 May 2014, where the ex-co members of the NPA were present. When these briefings briefings to the NDPP, are they the same briefings that ex-co members of the NPA are present?
There are two ways in which briefings takes place. In some briefings, we are present as members of EXCO. And in some briefings, we are not present. The NDPP is sitting with the team that is briefing him.
Yes.
Probably with his legal advisor.
Yes. Now, it appears that Mr. Hofmeyer's scribe may well be that he was not present in the meetings that in the meetings that the NDPP held, along with the prosecution team. But another person with a gripe is Advocate Mohatle. And as I understand her evidence and as I read it, Mohatle, Advocate Mohatle, am I saying it correctly?
Mokhatla or Mohatle? First time I hear about
Mohatle. Mohatla. Mohatla. Mohatla, yes. It's Advocate Mohatla. As I understand her evidence, her main difficulty was that she was not kept in the loop about the LAD activities. And she also says that not all cases, not all civil cases were dealt with by the LAD. And so she basically wouldn't account for how they were dealt with. in her view. What's your response to that evidence?
Firstly, I will accept that perhaps she was not kept in the loop by the very same person that she has delegated. But I had no way of knowing that she is not kept in the loop by Advocate Tita, because as she correctly says, she is the one who advised me to deal with, because remember at the time, Advocate Mokgatla was also appointed to act as head of SIU. So it would not be possible for her really to be available all the time. I was under the impression that they meet and then they discuss and then they agree, which is why it was easy for me, as she said here, that I would phone her. I would phone her because I'm assuming that we are together, because Advocate Tita is keeping her on the
Informed.
loop, to use her term. But what I later discovered was that the one of the challenges that I discovered was the lack of systems in LAD, basically. And it is necessarily the lack of systems, the monitoring systems that were not there at the time, probably because LAD had just started as the unit, essentially. When I speak about lack of systems, I must be understood to be meaning the lack of systems in terms of when the matter arrives, the days in which what should happen, and all of that. So much so that we had challenges where there were sheriffs who would come to the NPA to attach assets and all of those things. But we dealt with those things. And I don't want to be heard to be saying anything negative about Advocate Mokgatla. I relied heavily on her advice. One thing I can tell about you, Advocate Mokgatla is very bright. When it comes to dealing with the issues of the civil nature, I would rely upon her. That is why I would phone her at any time, because I know what I get from her is not something, that is not okay. I would rely on her advice. Only problem with the systems in LAD. Yes.
And then she also said that when the FUL matter was served on the NPA, and she had a conversation with you about it, you did not inform her that you had the memorandum from Breitenbach, and she gave you her advice, which she said would not change anyway, even if she had known that the memorandum was there. She gave you advice based on the understanding that there was this, on the understanding that there was nothing before you that you were dealing with at the time. Do you remember that evidence?
I do, Chairperson.
Yes, what is your response to that?
At the time when I got the advice from Advocate Mokgatla, there were no questions about are there representations that you have received from anywhere at all. The issue, what we had issues with, was the attitude, perhaps, of the FUL. So the question was, we have not even received representations from the FUL, and this is what they are actually doing, and all of that. And in any event, from where I sit, everybody had copied this particular memorandum. So even if it had arisen, I would not have quickly thought about the memorandum that she's now also referring to the memorandum, because from where I said, she also had the memorandum, even though I later hear from her now that actually I did not even receive that memorandum. at the time. But what we are talking about was the FUL representations. Yes.
And then finally, she identified a number of paragraphs in your GCP affidavit that she said she did not agree with. Is there anything you want to say about those paragraphs that she identified? Or do you stand by what?
Well, I stand by what I said in my application, in my affidavit in the GCP, because when you read my affidavit in the GCP, I'm not saying Advocate Mokgata in particular. I'm saying the team that was there, that I was working with at the particular time. And you must also bear in mind that whenever I mention Advocate Chita, I am mentioning it as a representative of LAD, because indeed he works for LAD and he still worked for LAD. And the understanding was that he is briefing Advocate Mokgata at all material times.
And the confirmatory affidavit that you say was, do you want to say something about the confirmatory affidavit that she says she said that she had been approached to file a confirmatory affidavit. She had agreed to do so, but she was later not given your affidavit so she could confirm what was in the affidavit.
I must admit that it must have been, I remember now it was due to time frames, because we indeed, the council's, my legal team had asked me to ask everybody who was involved whether they would be willing to do the confirmatory affidavit. And I did speak to everybody, and she's correct, and she had agreed. But I think we just ran out of time, and we thought that a view was taken that perhaps it's sufficient, because I mean, at the end of the day, Advocate Chita's affidavit confirming was there. And I think we forgot then to remove her name.
In the affidavit, yes.
Yes, Chairperson.
And then I want us to go to the evidence of Advocate Mlotshwa. In particular, there was something about pressure. The phone call that you made to him in which you said you were under pressure. Do you recall that?
I recall him saying so.
What's your response?
At no stage did I inform Advocate Mlotshwa about a pressure. There was no pressure that I was working under at all.
But later on you had a meeting with Advocate Mlotshwa at head office. Do you want to describe what that meeting achieved, the meeting in which you then informed him about the investigation in Katomana?
No. It's a pity, Chairperson, that I do not have my diary, my 2012 diary with me today.
You also keep a black book? A diary, sorry.
It is a diary.
Yes.
You know, I have learned in this process. I've learned so many things, basically. I did inform Advocate Mlotshwa that there is a case that I have made a decision that that case will be prosecuted and will be done by prosecutors not from his division for various reasons. But we're speaking on the phone, as he correctly says. And on the following day, if you look into the phone call discussion and also the following day, the letters that I subsequently issued to the various, to the DPPs that I am now informing them about my discussion with Advocate Mlotshwa. The only mistake that I regret, because I never knew that this is going to be an issue at all. The only mistake that I did was not to communicate with him in writing and confirm what we have actually discussed, as I have done so when I communicated with the DPP in the Northwest. So when we had a discussion on the day that he's mentioning and where I called them with Advocate Chauke, the discussion was not necessarily about informing him, because that has already been done. The discussion was about the process. How do we then ensure, how do we implement this process? And essentially, because he was an acting DPP all the time, the discussion about how do we get the delegations of the prosecutors who were supposed then to conduct these prosecutions in his division. That was the only decision, and just to let him know a little bit that this is what this thing entails and all of that.
Just on a lighter note, he appeared to be a little resentful that you didn't appoint him as the DPP. You appointed somebody else.
Chairperson, I have no powers to appoint. For starters, I did not appoint anybody else. The process of appointments for directors, yes, naturally, they are done with the knowledge of the NDPP. But what has happened in this case, if I may say so, we had a situation whereby just in all the divisions, the heads were males. In all the divisions, at the time, the heads of prosecutions who are directors were males. You know, so we didn't have women. And when these submissions were made to the then Minister of Justice, he made it clear that I want an appointment of an African woman, at least. We can't have a situation whereby all directors are males. And it really had nothing to do with the competency or incompetency or otherwise of Advocate Mlotshwa. No, it had something to do with balancing the gender. And I still say, even to date, that we are still dominated by males in the form of directors of prosecutions in the NPA.
Thank you. Is there anything from the evidence of Mark Adams that you wish to deal with?
Chris McAdam, I think the only issue that he had really was the issue about the OECD cases that were moved from him, which he later accepted, you know, on the basis of the fact that they were moved from him to allow space so that they can be able to focus on the TRC cases. You must recall that the TRC cases are a matter of concern. And I think for us in the NPA, and I'm sure for the families as well of those who were brutally killed. So that must be a matter of concern. So our primary concern with Advocate Abrams, when after my discussions with Advocate Andrea Kasseram, were that really something has got to be done. We cannot have a situation whereby we have resources doing something else that do not fall within their own mandate when they are not doing their own particular cases. And I must say, Chairperson, that some time back in 2016, we discussed this in the structure that I'm talking about, that is the National Operations Management Meeting, that we need to ensure that these cases get the full attention. At that time, we had just been able to deal with and issue a decision to prosecute in the case that involved the death of the sister of Nokutula Simelane. Yes, that was that at that time. So then my worry was that one day, because that case also, it didn't just come. It came because we're now taken to court for failing to prosecute on it, as generally as a law enforcement agent. So I was using it as an example that we need to focus on these cases. And I remember that I wrote an email to Dr. Pretorius, who's the head of the Priority Crime Litigation Unit, to say, I want a full report on these cases, the status, so that when we then meet in another meeting with the DPPs who are heads in the provinces, we can then see how best we can assist each other in dealing with the cases, because we understood that they do not have sufficient capacity in PCLU. And unfortunately, then I had to go on special leave. So when I came back again, now in 2018, this topic arose again in our meeting just now in October. And I issued a directive there to say that, you know what, that was 2016. I went on special leave. Nothing has happened on these particular cases. I'm not getting a report that at least 5 of them, this is the status now of where they are. So I issued a directive to say that, and of course, after deliberations with the directors of prosecutions and all those who were particularly in the meeting, my directive was simple, that these cases must then be taken to my office with a full report that indicates the status, what are the outstanding investigations, and where the offenses were committed. The idea was that we would then transfer, depending on which jurisdiction each case fell under, we would then transfer the case to that particular jurisdiction. As I understand that Deputy in my office, Advocate Trish Maske, did get that information, but as I stand here today, I don't know how far they have gone with dealing with those cases. So it was in that context, essentially, that I was really impressed by Advocate Kasaram's understanding of the fact that, you know what, we don't have resources in PCLU. Let's rather do away with OECD and give it to those that have got a mandate to deal with foreign bribery cases. It was never something that is meant to undermine Chris McAdam or anything of that sort. Yes.
And then just the week when we were preparing for this inquiry, on the Sunday, in the Sunday papers, the Akrizi allegations were splashed all the newspapers and your name featured in them. You now have had an opportunity to look at the affidavit that Mr. Akrizi filed in the Commission on State of Capture, and you've also looked at the transcript. What is your response to the allegations that are set out there, particularly in response to the timeframes that are referred to in the affidavits and the evidence?
Firstly, I want to state it on record. I have never been paid any sum of 100,000 by Mr. Akrizi, by Mr. MT, by Mr. Watson, and all of those names that are mentioned there. Never been paid any 100,000 by anybody. My salary comes from the NPA.
Have you been paid any money less than 100,000, for example?
I don't know if Chairperson wants to know my salary that I earn from the NPA.
No, I want to know if you have responded to those allegations before the Zondo Commission, because those allegations were made there.
My attorney has written to Zondo, to Judge Zondo's commission.
I said the Zondo Commission, because that's how it's known, okay?
Yes,
But
Chair.
the name of the judge
Yes.
is, we call him Judge Zondo.
Thank you, Chair.
All right, thank you.
Okay, so so this is your opportunity to deal with those, because, as I understand it, they are important for how you will be assessed on the issue of fitness. So even if you're still going to deal with it before the Deputy Chief Justice Zondas Commission, you are free to deal with them here, and so you're still dealing with them.
As I was saying, Chairperson, I've never received any money from anybody else, from Busasa or from anywhere else. My salary comes from the National Prosecuting Authority. My bank account is there to show where do I derive income from. Worst of all, in 2009, I had nothing to do with Busasa at all, where I would have then have to be paid for the services that I'm rendering to Busasa. In 2010, I had nothing to do with Busasa at all. And so in 2011, I had nothing to do with Busasa at all. And so in 2012, during these periods, as we have seen in my CV, I was a Deputy Director of Public Prosecutions in 2009. I didn't even have a PA at the time. I only got to have a PA when I was appointed as a Deputy National Director in 2010, but I don't know when really my PA was appointed as such, Ms. Palisa Madzi, as my PA. The only time that I got to be involved in the Busasa matter was through briefings that I was receiving in my capacity as such, as an acting National Director of Prosecutions. And those were briefings that involved other cases as well, not just Busasa as a particular case. I remember that there were briefings about the case that was also very old, in South Gauteng, in the South Gauteng jurisdiction. It was a case of Dave King. And there was also one that I can remember now. There was also a case in SCC, which was also Town and Bam. And then there was another case which was as old as coming from the DSO. It used to be called Project Yield. So basically, those were briefings that I'm getting in the normal course of and scope of my acting capacity. The process then would be that I would get the documents from the reports in particular. The reports, I would get them from Ms. Lipinga. So the DPPs or whoever is giving a report, these reports will be sent through Ms. Lipinga's office, email, or I think through her email. And then she will compile a beautiful file that you are able to use. And now when you open the file, you know that, oh, this is a report that comes from where, it's about this, and so on and so on and so on. And she has created a beautiful filing system because she has been in the office of the NDPPs. So it would be easy for any NDPP at any point in time, if she wants something that has got to do with this case, those reports would be in a I think they are in a cabinet or still cabinet that she had opened for filing purposes. So her role really was to ensure that when I do get those reports, they are arranged in a proper fashion, and also to coordinate those particular meetings as and when I have asked her to do so. I also had Ms. Madzi as my PA. So Ms. Madzi was my PA who was at all times sitting in my office, so that when there are phone calls, there's a person who's actually answering the phone. When there are documents that are sent to my office internally, documents would be either be from asset forfeiture unit, from the corporate services, or anyway. Then there's a person who's sitting there to receive those particular documents and perhaps arrange, give people dates on which I'm available to have meeting with them as and when is necessary to do so. At some stage, Chairperson, I don't remember at what stage it is. Ms. Advocate Gok, who's a prosecutor in this case, who was a prosecutor in this case at the time, did raise some concerns, and she said that she's not comfortable in proceeding with this particular presentation in the presence of Ms. Lipinga. And for me, that sounded weird. I couldn't understand why. I mean, she's an ordinary a secretariat who's just taking minutes here. What is the issue? And then she said, because she has worked with Mr. MT. But I did at correctional services, and she was a PA. They had a close relationship and all of that. But really, for the sake of progress, I decided, okay, she will no longer take part in this meeting, just to make you comfortable. Because if a person has worked with somebody, so what is the issue? Because we all come from different working environments. So for me, that was not it, but I just wanted to make her comfortable. So I then removed her from the involvement in the briefings where Busasa was going to be actually discussed.
Yes. And I mean, it's obviously if Mr. Akrizi had been at this inquiry, we would have asked him difficult questions, including the possibility that you were just a pawn in his grand scheme of looting and theft. You were just a pawn unknown. He was using your name simply to continue the business of stealing. We would have asked him those questions.
I would have asked him many questions, Chairperson, because as I say to you, I've never met Akrizi, I've never met MT, I've never been given money. Somebody, somewhere, maybe, must have been receiving money. I just don't know who that person is, but it was not me.
Yes. Is there anything else that you'd want to say to the panel about the terms of reference that they must act in accordance when they draft their report?
Thank you very much, Chairperson. I don't even know where to start, Chairperson. I did say that I will come back to some issues. In closing, I just want to make a request to this inquiry, and in particular to the Chairperson and her co-panelists, that really I would want a situation whereby at the end of it all, whether I am removed from the NPA or I am not removed from the NPA, I would really humbly request a situation whereby the independence of the prosecutors is not weakened. Instead, this inquiry must find ways in which it can really strengthen the independence of the prosecutors. The independence of prosecutors is extremely key in the exercising of a discretion whether to prosecute a person or not. And in my view, it should really take the same format that, or the same protection, for lack of a better words, Chairperson, that is afforded to the judges. Judges exercises their judicial independence when they issue judgments. And all that I'm saying is that when a judge or a magistrate exercises that judicial discretion when he issues a judgment, that he does or she does on the basis of the evidence that is presented before her by the state and by the defense. All that is there is an application of the legal principles on the basis of the evidence presented and the offense within which a person is particularly charged. I've never heard or seen, therefore, a situation whereby because of that exercise of that particular judicial discretion, that a member from the judiciary or even, is subjected to a process, because that would weaken our judicial system a lot. We have instances, Chairperson, whereby people get convicted in the lower courts. And because we have systems built in the judicial system of our country, those systems are what we then call checks and balances. The case then goes on appeal. And there are instances whereby the appeal set aside the decision of the lower court. And it is not going to be said because the decision of that particular lower court is set aside, then suddenly the lower court, a magistrate or presiding officer must be exposed in a particular process. All I'm requesting is that along the same lines, this inquiry must assist us as the NPA to get that kind of a protection, so that when prosecutors exercise their prosecutorial discretion, having applied the same legal principles that are applied by the judiciary, albeit through the evidence which is contained in a police docket, not acting in any malafides. That's really the fear that you have, that if your decision as a prosecutor is reviewed, you might be exposed to a particular process, which is a disciplinary. I know this is not a disciplinary process. The chairperson has said so more than many times, but all I'm talking about is just a process itself. It does induce a sense of fear. I have spoken to prosecutors, a number of them, and they say to me, you know, Advocate Jiba, can I adjourn, Chairperson?
Sorry, Chair, can we take a 5-minute break?
You may.
Thank you.
Let's just take a lunch break, and we'll come in 10 minutes earlier. Okay.
Thank you.
Thank you.